The broadcast is now starting. All attendees are in listen-only mode.
Hello, this is Jennifer Schauf, and thanks for joining us in our Government Contracting webinar series. We're in the final day of the final week, which is week 10 in the series, and today we're joined by John Williams of Polario Mazza, who's going to be talking about sole source contracts, specifically for SBA 8A certified firms. The full list of all of our webinars can be found on our website under the webinar section. They're all recorded, they're all complimentary, and there's over, I'll say, 50 or 60 webinars on a variety of government contracting topics. A little bit about us: we're based in downtown DC and provide services for both product and service companies that are selling to the federal government. Our service offerings range from capability statements, proposal writing, GSA schedules, contract compliance, and more. We do host events and seminars throughout the year. Our next event over at the Kennedy Center in Washington, D.C. will be on Monday, October 23rd. We anticipate about 200 government contractors. My background is listed on this slide, but more importantly, I'd rather dig into our topic today and welcome John Williams. Thanks, John, for joining us. Excited to have you here with us today, and anxious to hear about your presentation on the 8A Sole Source Award. So without further ado, I'll hand the floor over to you.
Great, thanks, Jennifer, and great to be here, everybody. Good afternoon. Like Jennifer said, my name is John Williams. I'm a partner at Polario Mazza, which is a law firm in Washington, D.C. I've got over 15 years of experience representing contractors on a wide variety of topics. Basically, everything you end up encountering with the federal government, either I or our firm probably handles it. That's government contracting is really our bread and butter. And in particular, we have a niche with the small business procurement programs. And that's what we're going to talk about today. In particular, the 8A program and sole source contracts. And I'm going to start off by just giving you a little bit of a sense of the background on the program. So the 8A program's been around for a while, and in the early days of the program, it looked very different than it looks today in many respects. There were no time limits. Now it's a 9-year program term. There were no restrictions on sole source awards. We're going to spend a lot of time talking about the restrictions that they do have now on sole source awards. There were no business mix restrictions, and I am going to talk a little bit more about business mix as we move forward. What this means is that as you move through your 9-year term in the 8A program, SBA wants to see that you're getting a good mix of 8A work and non-8A work, because the idea is they don't want you, once you're done with the program in 9 years, you're not eligible for 8A contracts anymore, new ones. They don't want you to fall on your face, so they want you ready and doing enough non-8A work while you're in the program. So that's what we mean by business mix. There are a lot of issues in the rules today on changing ownership and selling 8A companies and transfer of 8A contracts, but those things didn't exist back then. So it's a different world for the 8A program now than there was back then. And so just a quick overview of the requirements for the program. You have to have ownership by American citizen. The company itself has to be a small business. It's going to have to be majority owned, which means 51% or more, and controlled by socially and economically disadvantaged individuals. To get into the program, you have to demonstrate to the SBA a potential for success. They want all of the companies in this program to be a good reflection on the program, and that they're actually good candidates for the business development assistance that the program is intended to provide. So to judge that, they generally speaking are looking for companies that have been in business for at least 2 years, and that you'll show them through your tax returns and financial statements and other ways that you've been successful during those 2 years. Doesn't mean you have to have millions of dollars of revenue and big profit margins, etc., but you've got to show them that the business is on the right track. It's possible to get into the program even if you haven't been in business for 2 years, but you have to get a waiver, and getting the waiver requires that you make some additional showings that even though you're a very new business, you are going to be successful. And you also have to have good character. So, they're going to be looking at things like arrest record and suspension and debarment and things like that. Next slide is just going to give you a little bit more of a drill down on the social disadvantage component of the 8A program, that the individuals who, like I said, who have to own at least 51% and manage the business need to be socially disadvantaged. And you can get there either by being a member of a presumed group, or if you're not a member of a presumed group, then you have to be able to show evidence to the SBA that you have social disadvantage. And to do that, you have to identify at least one objective distinguishing feature. And being a woman or being a service-disabled veteran are two types of objective distinguishing features that we have seen many clients get into the 8A program through. And then you have to be able to document personal experiences of substantial and chronic social disadvantage and how those experiences have negatively impacted you in either getting into or advancing in the business world and your education. So you need some personal experiences, and there's no real magic number there. You need more than one. Ideally you have multiple specific examples, and then you have a chance to make the necessary showing for social disadvantage. Next slide that'll pop up here for you just gives you a little bit more of a drill down on the economic disadvantage component. So again, 8A firms have to be at least 51% owned and controlled by socially and economically disadvantaged individuals. And the title of the slide here makes note that this is economic disadvantage at the application stage. So it's just good to keep in mind that the economic disadvantage criteria that you're seeing on the slide here change once you get into the program. The numbers go up. So you have a little bit more room on your personal net worth and your income and your total assets once you're in the program, because SBA recognizes they want the businesses to be successful in the program, and if the business is successful, then the disadvantaged owner is going to see some of that success too. So, but just general thresholds here that you have to stay below to be eligible for the program. And the last sort of background slide is going to pop up for you next here on SBA annual reviews. And this is just to give you the sense that when you're in the program during your 9-year term, SBA is annually monitoring how you're doing. So you have to submit information to SBA. There's an annual report submission, and we've listed here, what you have to submit. And this is relevant particularly for sole source contracts, and I'll talk about that in one of the later slides, because if you're not meeting all of the SBA's requirements on an ongoing basis in the program, they can take some actions they could potentially terminate you from the program or graduate you early so you don't get your full 9-year term, or they can put some limitations on you. Maybe they let you stay in the program, but they're not going to let you take full advantage of the program. And one of those limitations that the SBA can impose on you is to prevent you from getting new sole source contracts. So with that, let's turn to the next slide where we'll start talking about sole source contracts. And why would that be an important limitation? If SBA didn't like how you were operating in the program and restricted you from doing new sole source contracts, that would be a big deal, because sole source contracts is one of the critical advantages of the 8A program over the other set-aside programs. And it's one of the central marketing tools that you will use as an 8A firm. And that is because it's much easier for contracting officers to issue a sole source 8A contract than it is to issue other types of sole source contracts. And I hope you'll join for the next webinar that we're doing on sole source contracts and the other set-aside programs. So we will talk then about how the sole source contracts work for STVOSB and HubZone and women-owned firms. But 8A has a real advantage over those programs because the contracting officers do not have to consider the rule of 2 before they do an 8A sole source award. So, if you're in the set-aside world, you need to know what the rule of 2 means. This is where the contracting officer has a reasonable expectation that at least 2 offerors will submit a proposal at a fair and reasonable price. They have to do a competitive set-aside. So if the rule of 2, there's at least 2 companies out there that could do the work as a small, an SDVOSB or HubZone or what have you, if that rule of 2 is satisfied, it has to be a competition. It can't be a sole source. But that's not the case for 8A. We don't have to worry about the rule of 2 for 8A sole source. So that's what makes it so easy comparatively for contracting officers to do 8A sole source awards. Now, sole source contracts can't exceed the competitive thresholds here. So if it's $7 million for manufacturing contracts and $4 million for all other types of contracts. So, they can't be issued at any dollar amount, but as long as the contract can stay below that competitive threshold, the contracting officer can do the 8A sole source without having to worry about the rule of 2. And that's really, really a big advantage of being in the 8A program. So then the next slide will pop up showing you some of the mechanics of the 8A sole source awards. Sole source contracts can be awarded to 8A companies. It can also be awarded to 8A joint ventures. And an 8A joint venture would be an entity that is majority owned by an 8A firm, but might have a non-8A company as the second partner in the joint venture. It could even potentially be a large business partner if the 2 companies are in a mentor-protege relationship. To be eligible for an 8A sole source contract, you have to be 8A at the time of the sole source award. So obviously, when you graduate the program, you're not eligible for 8A sole source awards anymore. And as I mentioned earlier, you have to be in good standing with the 8A program to be eligible for 8A sole source awards. So, we've had several clients that if they get out of whack with the business mix targets, because as you move through the program, there are targets for how much of your work should be 8A and how much of your work should be non-8A. And if you're not where you're supposed to be, your SBA representative may suspend your ability to obtain sole source contracts until you get back where you need to be on your business mix. So it's important, really important to stay on top of the ongoing eligibility requirements for the 8A program, because you don't want to lose this critical tool of 8A sole source. You want to be able to take full advantage of that throughout your time in the program. And just the last point here is just a little bit more on the mechanics of how this works. That the procuring agency submits an offering letter to the SBA, and then the SBA will accept it. And so, you as the 8A company, you'll be working with your customer agency, that you're marketing to them and saying, I can do this work for you. If we keep it under $4 million, it can be an 8A sole source contract to me. And so you're advocating to the procuring agency, and then the procuring agency is going to SBA and saying, well, let's do this. And hopefully you've also talked with your SBA rep, so the SBA is prepared for it, they're on board with it, and this is all a pretty simple process. But if for whatever reason SBA is dragging its feet on the acceptance part of it, if the contract is over the simplified acquisition threshold, the SBA is supposed to make that decision within 5 days, or the procuring agency can go ahead and proceed with the award. Just to give you a sense for the FAR clauses, there are certain FAR clauses that will be included in an 8A sole source award. And the main reason I wanted to bring this up is because one of the clauses I've referenced here, 52.219-12, this is for 8A sole source awards. This clause says that you as the 8A company are not supposed to do any subcontracting to firms below you on the project without approval of SBA and the procuring agency. And I have to say that I see that often overlooked, that You know, the 8A company gets the sole source award and then turns around and subcontracts a chunk of that work to somebody else, but they didn't get SBA to approve it, they didn't get the procuring agency to approve it. In most cases, that's probably not an issue, and everyone's probably at least implicitly aware of the relationship. But it's not an issue until it becomes an issue, you know, where maybe there's something wrong with the subcontract, or, you know, we need SBA's help, but they weren't aware there was a subcontract, they didn't approve it, you know, so you want to make sure you're aware of that requirement and step through it if you're going to bring on a subcontractor on an 8A sole source contract. And, you know, you're going to be subject to the same prime contract performance requirements that you would be subject to on any other type of set-aside contract. Next slide coming up on the competitive thresholds. I mentioned before it's the $7 million and the $4 million standards, depending on what type of contract it is. Those are supposed to increase every 5 years, so we'll see another adjustment in a few years from now. So these numbers will probably stay this way, at least for the next few years. The little example here comes right from the SBA's rules that if you have a contract that's anticipated to be 3.8 million, but then through the course of negotiation it increases, that's okay. You just can't end up more than 10% greater than the competitive threshold without justifying it. And they don't want you breaking up a larger contract into smaller pieces just to try to fit them all under the competitive threshold. There are a number of special rules for ANCs and tribally owned firms and Native Hawaiian organizations for the 8A program. If you're at all familiar with 8A, you may already know that. But in particular for sole source contracts, there are some unique rules for these types of firms. The competitive thresholds don't apply, so they can go above those amounts, although they can't go above 22 million for an 8A sole source contract without a justification and approval. NHOs are actually only exempted from the competitive threshold for DoD contracts, which is interesting. And there is this rule that for all 8A firms, if you ultimately reach either $100 million in combined 8A sole source and competitive contracts, or you get to 5 times your size standard. So if you have a $20 million size standard, then that would also be 100 million, but then you're no longer eligible for sole source contracts. And I'm sure many of you would say, well, that'll be a nice problem to have if we get there, but that limitation does not apply to ANCs and tribes and NHOs. So they just have special rules in the program. And finally, one of my favorite topics, protests, probably one of your least favorite topics. So we do a lot of protest work, and I guess the good news from your perspective is that there aren't a lot of protests on 8A sole source contracts. So you can't have competitors challenging 8A status or even size eligibility for sole source. And it's pretty difficult to make a bid protest out of an 8A sole source contract. It's not impossible, but as I noted here, you're going to have a smoking gun that there was bad faith, or you're going to have a good argument that the contract is too large to qualify as a sole source. Otherwise, it's unlikely that you would have a good protest ground against an 8A sole source contract. So that's just another reason why it's a really valuable and important tool for 8A firms.
Thanks, John, for your presentation today. It was very informative. And thanks everybody who was able to join us. We are going to jump back on the line again in about 10 minutes to cover sole source contracts for SDVOs, hub zone, and women-owned companies. Some of the things John mentioned in his presentation today, the rule of 2, simplified acquisitions, joint ventures. We've recently done webinars on those. They are available on our website under the webinar section. If you have questions about anything that John covered today, or any other government contracting matters, his phone number is listed on this slide along with his email address. And like I said, we're going to jump back on the line in about 10 minutes with a new dial-in and a new registration link to cover sole source contracts for the other set aside. Thanks, John, for joining us today. Thanks, everybody who was able to make it as well.